Only where the IBC had quorum could it make such a fundamental determination. Similarly, verification of signatures and determination of whether or not they met constitutional requirements was also a question to be determined by the IBC as a business of the Commission, with the necessary quorum and after full and critical considerations. Hence, even under the holding in Isaiah Biwott Kangoni case, the verification of signatures and the determination of whether the constitutional threshold had been met for purposes of Article 257(4) of the Constitution are definitionally policy considerations which required quorum under paragraph 5 of the second schedule of the IBC Act. We say so because one of the IBC's key mandates under Article 88(4) is to conduct referenda. This mandate is also emphasized in Section 4 of the IBC Act. Section 8 of the Act places composition of the IBC at 7, the chairperson and 6 other commissioners. On the other hand, paragraph 5 of the second schedule to the Act puts the quorum at 5 commissioners. The fact that IBC did not have the quorum of 5 members when it conducted verification of signatures and determined that the BBI Secretariat had met the constitutional threshold under Article 257(4) of the Constitution to move the process to the next stage is not in doubt. Equally, not in doubt is the fact that the statute requires that quorum. This statutory provision was not inserted for cosmetic purposes. It underlines the critical constitutional roles placed on the shoulders of the IBC. If the Constitution placed the threshold of voters to support a constitutional amendment bill at 1 million to be verified by the IBC, such a high threshold could not be determined by an organ that did not have the statutory quorum. The Constitution placed the minimum number of commissioners of independent commissions at 3 and highest at 9. Parliament, while appreciating the important mandate the IBC discharged, picked a high number of 7 commissioners to constitute it and placed the quorum at 5 members. Taking into account how serious and consequential amendments to the Constitution are, all decisions connected therewith, including the verification of signatures in support of a popular initiative and the determination whether or not the constitutional threshold and Article 257(4) has been met, we conclude that these decisions could only be taken by a quorate IBC. We also conclude that the IBC Act categorically places the quorum of IBC for purposes of transacting business at 5 commissioners. Finally, we conclude that the IBC did not have this quorum at the time it made the consequential decisions related to the Constitutional Amendment Bill. It therefore follows that all the decisions so made by the IBC in relation to the proposed constitutional amendment and in particular to the Constitutional Amendment Bill were invalid, null and void for lack of quorum. And I hand over to the